This particular matter, there are two matters which have been listed, which are prayed not delisted from your lordship's court because.
Yes, we have said that you go there.
No, your lordship have admitted this matter, that is WPC 24609 of 2025, that is sub-item 29, on the ground of principle violation of principles of natural justice. And the second point now, my lord, is 130 proceeding will not be maintainable as and at that particular.
Take that plead before the tribunal.
Your lordship's order, Lord, kindly, Lord, your lordship.
At that point of time, there was no tribunal. At that point of time, there was no tribunal. We were admitting everything. Now the tribunal is there. You can agitate. You are still within the period of limitation.
No, I'm not. I'm not within the period of limitation. And this NHA.
That extended period up to June.
No. I approached.
The first appeal order has been challenged.
The first appeal.
So your tribunal can be no difficulty.
Right. The writ petition, my lord, was filed after 35 days of the expiry of the.
Whatever is the reason.
So this particular matter.
We are saying that let you come through a tribunal. Will you know what the tribunal will do? Come.
National Highway Authority's matter is pending before your lordships. In addition to it, my lord, your lordship has specifically admitted this case because 2nd of February is fixed for show cause. 1st of January he passed.
Let us start with one main matter.
But
we'll go one by one, sub-item, please. Not in a haphazard manner. Just wait.
I'm sorry. I thought, my lord, your lordship.
Let us see one after another. One 1943.
1943 about 2025. 9516 of 95.
I will go to Tahil. Yes.
1021625.
Yes,
1536025.
Fine, lordship, that one. Interval of the lordship, so it to continue till lordship. That interval of the lordship, which continue lordship. Obviously, after payment of 10%,
You have already paid, it is automatic. There is no need to give. Yes.
15408.
Yes.
Yes.
15464 of 2025.
Who is there?
15464 of 2025.
Lakshmi Narayan Sahu.
Yes.
15464.
No.
Your lordship can dispose of by the order dated. Your lordship may kindly look into order dated 26th August 2025. Only on this ground this writ has been admitted.
Let us see.
Your lordship.
Give me a file.
15464.
Please orders. So that is the reason. So same chapter. Yes.
15951.
I'll go to the tribunal.
Yes.
17590.
Yes.
17703.
17703. It is still party. Show us. Yes.
I ordered the 15th July 2025. Your lordship. Subsection. Your lordship.
17704 of 2025. Same. This is
What is this?
17735 of 2025.
Who is the hearing?
This
Same, it is still party.
yes, ma'am.
Your lordship. Same. By order dated 15th July.
18560 of 2025. 18560 of 2025.
Same, by order dated 26th August 2025.
Four. Objection is under subsection four or what?
Your lordship, that is to things.
Yes, that is it.
18656 of 2025.
Your lordship, 107.
Right. 18656. Yes.
You already.
18911.
Same order minor.
Yes.
19448.
Same order minor.
19602.
Matter is quite different from this.
What different?
Matter, because petitioner has already paid his due before the relation. But
What? If you go there, you can agitate this point. They will just go and make it. They are the last fact finding authorities.
Paragraph four, not first.
Your lordship.
Yes. Don't go back to that.
1160.
Yes.
Please.
20627.
Hey.
21462.
Same order minor.
Yes.
21504.
yes,
Yes.
21507.
yes,
22461. 22560. 23011.
Tribunal alert.
23087.
Ma'am, it will be different to that much. In this matter, in the similar case, your lordship has already acted by remanding the matter to the author.
I admitted that there was no constitution of the tribunal. So now there is a constitution of a tribunal. You are within the period of limitation. You just go. June is the last day. Yes, sir.
Similar order is also be affected.
No.
23701. 23960. 24048.
yes,
24204.
yes, Lord.
Tribunal, yes.
24520.
Yes, Lord.
Oh,
Yes.
Yes. 24577.
Yes, Lord.
24609.
May I please be noted? Lordship, kindly peruse order dated 25/9/2025. Paragraph 2. Your Lordship have quoted that order results, the second page of the order, where your Lordship have found out that this particular show cause notice was to be filed on or before 1st of February 2025. And the order is, my Lord, passed.
It was on a different,
It was on a different footing. And added to that, my Lord, proceeding here, my Lord, was initiated under Section 130, pursuant to action under 167.
Your lordship, paragraph 2.2 my submission, paragraph 4 and 5 may kindly look in.
And my Lord,
Paragraph 4
and my Lord,
from this fact. For
and keeping it on a day when we take up the this matter. Taxation matter.
Your lordship.
Calling from the 21st. After Lordship, sorry.
Which one? No, so we are just detaching it and then it will appear on a tax day.
Yes.
The interim order to continue.
Obviously, it will continue.
24691. 691.
Yes.
25276. This one. 25671.
The
26555.
Yes, sir.
26556.
Yes, sir.
This one. 26748. 28974.
The previous order has been reported in 154 IPI. That has been, earlier order, my last order has been reported.
29415. 29562. 30422.
30422 minutes. Occupy partly here the bias of the notification number 9 and 56 pursuant to 168A, which has been challenged before Lordship in several writ petitions, is come for the first time. Similar orders have been passed. 168A and similar orders, this has come for the first time.
Next.
21st May. 21st May.
Thursday.
Yes, sir.
This Thursday.
List is already published.
Why is it challenged?
So this is
I'm just talking about why tax day is a Thursday, tax day.
This Thursday.
This Thursday. These
14th.
matters will come up this Thursday when it is listed.
14th.
So we'll see to it on that day. Pass the order.
no orders have been passed to this particular case.
Oh, we'll come, we'll pass an order on Thursday. We are detaching it and then posting it on Thursday.
Much obliged.
Yes, ma'am. 31662. 32231 of 2025.
Yes.
Two matters to that. Yes. 14th.
Yes.
No, that is only challenging the letter dated 29/1/2026 as well as 18/2/2026. Where the authorities have blocked my portal mail for 180 days. The last occasion was
Beyond?
blocked my portal. Since they have proposal has been made to blacklist me, my company, then they have, without any final order, they have blocked my portal mail.
Yes.
Portal has not been blocked. The Lordship may kindly seek
What more?
instruction.
But it is there on 18/2/2026.
Where is that? Where is the
May
letter?
kindly see para 12.
Where is the letter?
That is page number 34, annexure 9. There are three order to company.
That's just one minute.
That is a request to the chief manager. May kindly be blocked for 180 days. This is the instruction.
But the name of the bidders, it does not appear that it has been blocked.
No, that is same superintending engineer has given this instruction. Para 12 your Lordship may kindly see. They have narrated the entire fact. Proposal for blacklisting is pending. Your Lordship may kindly see 12. That it is respectfully submitted that the proposal.
Yes, so nothing,
No blocking of registration
No.
portal.
nothing.
And Arjuna,
Sorry.
my prayer is that
It was a request, but that request has not been accepted.
And this is the instruction from the e-procurement cell also. They have said that it has not been blocked. Those who are believing.
then my lord, it is one part of my other part is I'm also challenging letter dated on 29/1/2020. This is where the proposal had been made to blacklist.
Where is that letter?
That is page number 32. My lord, good.
Look. No, 22 is a
32.
30.
Annexure 7.
It was declared as the L1 bid.
Yes, sir. So they have to initiate a proceeding.
My lord, that is there, my lord.
So
But-
they can initiate a proceeding. How can you, they have not blacklisted you without a sugar. Ignite. They say the ignite the proceeding.
That is in fact initiation.
That's the ignite means the initiation.
I would like to say that without issuing any show cause, they have issued the.
They have to say that they have to follow the, whatever the steps are required.
On 10, I'm just submitting those facts. On 10/12/2025, they have issued the contract, the notice again, and contractor has already been allotted to any other contract. That work which has been allotted to me, allotted to any other contractor, my lord, without issuing any show cause, my lord.
No.
No, my lord, they have issued show cause on 13/1/2026, my lord.
Yes,
And
or you have not responded to the show cause.
my lord, I have responded. It is in page number 20.
No.
My lord. Yes, my lord. I have sorry, it is in page number. I have responded and they have said that it is not satisfactory.
Where he has not responded?
Yes, my lord. That is in page number 31, annexure 6, my lord. But prior to issuing so cause, they have issued notice again for the tender, and tender has already been allotted to any other contractor, my lord. I have replied, my lord, page number 31. It is revealed from the annexure 8, page number 30, that my so-called reply is not satisfied, my lord.
Where?
That is in page 33, my lord.
But to think that it is not satisfactory, only one.
Correct, because he has not taken out. It's simply say that I was ill. But there is no document which is forthcoming along with that. So they say it's not satisfactory.
And in his reply, she is referring to a ironic fever. And the stand taken is I was suffering from malaria. And those documents.
Where is a stand taken for malaria?
In the writ petitions, he has enclosed the document saying that I was suffering from malaria, and whereas in the so cause it is written as ironic.
But there is no document which was produced before along with the response.
That is
Never asked me to submit any documents.
Oh, acha. Oh, you thought that if they ask you, then you will give. Even if you take a defense, you are not supposed to give any evidence
My lord,
corroborating your stand. That's your contention.
I'm ready to produce, my lord.
No.
Waiting.
Madam, a show cause notice is given showing that you have failed to deposit. You took a stand that you were suffering from ironic fever. Will you not, along with that show cause, reply, you will annex some document in support thereof? Whatever the ready, will they ask you to produce document? Why?
And my lord, page
Still
number
it is
32 is
premature.
here.
Still it is premature.
They have not.
You have still further opportunity to submit.
My lord, just
They have kept it open for you.
Sorry.
They have not yet decided anything.
Yes, my lord.
It is still open.
And my lord, at page number 32, Annexure 7, second paragraph, that subsequently, I'm just reading out, subsequently a show cause notice was issued to the contractor by the office letter number such and such, allowing further period of 15 days for complaints, but they have never, it is there that they have supposed that why a disciplinary proceeding should not be initiated against me. They have never asked me to complain the order, the letter dated 26/11/2025, madam, where I have asked to pay the deposit, unless on a deposit. Sorry, madam, that is, yes, my lord, where I asked to deposit 1 lakh something, but they have never asked me for complaints of the. And it is submitted no response, where I have already been responded, my lord.
That's a wrong feeding. That was actually a show cause notice in contemplation with the disciplinary proceeding.
Finally reply why disciplinary proceedings should not be initiated, but here it is.
Yes.
Allowing further period of 15 days for complaints, but it has never been asked.
It was simply a preemptive steps that why it should not be initiated. Now, if they want to initiate, you will get a further show cause. That is what is there.
7 and 9.
Yeah.
7 and 9.
Huh?
She is challenging 7 and 9.
Correct.
Annexure 7 and 9.
True.
So 9 they have not given effect to.
Correct.
7, the stage has not come.
The petitioner.
liberty for the cause of control, why liberty?
That is a further independent cause of action for that liberty. No,
Item 21.
give a file.
gender. Yellow gender and gender come out.
Just. Yes, L1 has failed. Then why?
The case of the L1 was considered by the tender committee once again.
Hmm.
And in the meantime, the work order has been issued in favor of the L1.
What more?
That is so. The proceeding was
Then your cause of action goes. Then you'll have to. Then you will have to.
the tender. We can.
Whether the tender committee can revisit or tender committee can visit, all these are the fresh cause of action. For that you'll have to. But this writ petition is not better. It is not.
That's with that observation, if the petitioner has.
No, what?
I will.
The instant writ petition.
After return of the tender. That is the financial service.
Don't try to use as an evidence.
That is there.
No, sir.
Item number 22.
He wanted a judgment to be used as an evidence. Yes?
You see, regarding the issue of corrigendum not meeting the requirement of Article 166, 1 and 2 of the Constitution of India.
So violation of rule
In
11
this
of
case-
Odisha government rules of business manual and section 21 of general clauses.
Annexure 1 on the challenge matters.
Whatever we have found that it is not, it is by an executive instruction only. So in that event, we have permitted him to make an application under the unamended or unsubstituted. If such application is made, then you will consider it, but will not take a final decision without the leave of the court.
By the order of governor, one not mentioned, I have got a decision, Supreme Court has said, mere by omitting to write the expression by order of governor, that will make the, or do not make the order invalid.
If it is in fact passed by the governor.
Ordered by you.
May I
If
suggest-
it is passed by the governor with the order of the governor, we are happy. Mere omission will not do. It appears it is purely at the office level. And that too, I can understand that if the word is wrongly given, it should be are. I can understand that this typographical error or ministerial error, no difficulty. Here you are substituting the whole. Can't do it.
Four bench will only be multiple applications.
Sir, what are you talking about? How can it be done?
May I suggest something? Instead of I will counter, you let me dispose it with the direction to government to issue the corrected correction. By order of
Also
court.
relying on-
What? The corrigendum has to go. It has got no value.
That has to go, but we will proceed with the further modification.
No, that is up to you. But this cannot
Why not?
stand. This cannot stand.
Because we have already received 1,500 applications with the application fee of 3 lakhs each.
without the approval of government.
So what is the fate of those applications and all
But I
that?
am not.
You can observe that.
Supreme Court language is very, it is well settled that if an authority has a power, trace it to source available.
Absolutely. I was asking sure. But that is not there.
That source you have to disclose.
Which judgment?
That is N Money versus Sangeeta Theatre.
He is relying.
No, I don't know what is like.
And money's judgment you are relying.
This judgment have related to it like Maheshwar Pangarkar versus State of Bombay. It is held by the court so and so that clause 1 and 2 of the article 166 are directive only and non-compliance with them does not result in the order being invalid.
That is a different way. Here is a case which cannot be done.
21 also is there. General Clause Act. Section 21, General Clause Act. If you are deciding, amending in the same manner, you will be.
That is the so source you have to disclose.
Right.
Even if it is not stated there in
Learned government advocate is saying that suppose if there is an omission to write that by an order of the governor or the governor has been pleased, that does not really vitiate or render that particular corrigendum to go. Say absolutely correct because it cannot render the document to go. But show me. If you can show me it is an order of the governor, no difficult.
What's the seat judgments? In fact, we have found out 2 judgments. Last week also you asked me to find the judgments. We have worked on that. We have got 2 judgments of the same. Area 22, first 2024, 2 SCC 570. Area 22. Exactly what should be find is at page of this compilation. Yes, I will copy it. There is a copy. Open the book.
Yes.
Then
Second judgment.
one more judgment, ma'am. Can you see page 23, para 17? This is regarding rules of the use. Para 17 at page 23 of this compilation, para 17. Para 17, ma'am. This is regarding rules of business, read with Article 66, 1 and 2.
That's a different. That's unless
Not exactly on the.
unless the governor gives, the chief minister has all the powers to call for the records, vary it.
Right.
But that's obvious. That's obvious. That's all the ministerial or administrative work.
Has to be by the Council of Ministers in terms of their assembly.
Whatever is there,
Right.
they have to.
Para 22 is relevant.
That is para 23 is
This
that's very clear.
first case is
Huh?
this one.
That's the paragraph is very clear. 22. Give me a General Clauses Act.
Next year.
They proceed to follow by original notification of the.
Yes.
Total will.
So you have not followed.
Yes.
It is something like that. Odisha.
Odisha General Clause.
Odisha General Clause Act is there.
Same.
Same. Exactly same in Baru.
Exercisable in the like manner.
Original.
The challenge is made to a corrigendum
application we have received so far. For protection of the interest of the applicant, but after correction, the new notification will come. They can also give consider for that purpose, that observation.
What observation?
Otherwise, you have to refund now at the rate of 3 lakh, 1,500 applications.
No. It is only in relation to the one application or multiple applications. That's all. So somebody has filed one, so you can give them an opportunity. If you want, you can file multiple. You need not have to return.
No need to.
Such an observation may be made by them.
There is no return of the application.
Commission will be problem.
Got it. In view of the laws so enunciated, the college
want the counter is not necessary. You could, Lordship can modulate the language by saying that it is point of law in involve counter maybe not be.
That is what I have said.
But my observation that government advocates submit that it is not necessary. That is that way your Lordship can modulate the language.
Why you are afraid, sir? It's a pure question of law.
To say some government himself may counter.
Anyhow, will do it, but should not be apprehensive. It's a pure question of.
So can I make a small preamble? An identical same, one more repeat is there. Can it be found for and disposed of in the same line?
Which one?
The WPC 13627 of 26. It's not on board.
No. Without on board,
No,
no.
it's not on board. I am asking a special notice can be disposed.
No, no. No. It has to be listed next day.
I will put a request towards you and want to get that.
Okay, I will modify. That's why I say why you are apprehensive as a government advocate. You should be bold enough to bear that responsibility.
Government technician transfer.
Nothing. It's a pure question of law. I have also said.
That is what I am saying. Your question, sir?
Yes.
Item 23.
Leads to unilateral revision of additional charge. That's a single order.
What?
Unilateral revision of
It is
additional.
covered or not?
Yes, please. As it's not being covered.
Covered. That Sandeep, Sandeep Chandak, he wanted to verify whether it is
Yes.
covered in view of Sandeep Chandak.
That's first. We have deposited the amount. Those may be adjusted in our future.
Additional charge you cannot
Again, in terms of the impugned order, interim order passed in. Only one matter, 24.
It's 23.
That is already covered. Sandeep Chandak WPC number 6. It is covered by that. Capacity.
Next.
Item 24.
Because the matter where the average turnover clause has been and the estimated cost also has not been indicated. The lordship comes to page 98 for a moment. Why I'm pressing on that, in 98 the lordship sees the previous tender which was opened by the temple itself. The lordship sees the last line. This was in 2000.
1 crore, not less than, so.
This was the 2023 tender. They have 1 crore. Now 500 times inflated, they have gone for 10 crores. They have made lordship on the last occasion. I showed you a lordship at page 78. The lordship sees. Page 78 is the minimum manpower requirement if the lordship sees at page 78.
Yes.
That's page 78. That is the minimum manpower requirement. Now, on the basis of that, the lordship comes to 107, my calculation. Page 107 is under Annex 6.
Yes.
The lordship sees the manpower which they have given under Annex 2 to that tender document. I've calculated and the turnover comes to, estimated cost comes to 3 crores 80 lakhs, 33 odd, my lords. So 30% of, as per the guidelines, 30% of that becomes the estimated cost. 30% of the estimated cost becomes the annual average turnover. They have gone much beyond that. And even if the lordship sees from their own document, if I calculate, it comes to 3 crore odd. And even they have not reflected the estimated cost. If the lordship comes to the documents which have annexed, the guidelines which have laid down that the estimated cost has to be given, and that has to be 30%. All CDC guidelines, including GM, as on date. If the lordship comes to page 111. Given point number 4, your lordship. In fact, it starts from 108. So, sorry, your lordship can start at 108 also. Point number 3, your lordship may see.
Yes.
The central government has laid down specific guidelines. How in such cases, if the lordship sees point number 1, 3 Roman 1, for a work with an estimated cost of 15 crores to be completed in 2 years, the criteria for average annual turnover in the last 5 years was kept as 15 crores, although the amount of work to be executed was only 7.5. Now they have given such examples. And thereafter, at point number 5, if you lordship see that page 109. 5.1, Roman 1.
Yes.
We give the 30%. Now the next page, 111, which I was initially showing you, lordship. The CBC guidelines has referred to the Honorable Supreme Court judgment. Point number 4. And your lordship has the 6th line, technical specification, thereafter estimated cost. After the words technical specification,
Yes.
estimated cost is mentioned.
Yes.
That judgment also I have with myself. And then after, this GM portal also 113. So my submission before lordship is, it has to be a reasonable fixation of the annual turnover clause. And accordingly, the estimated cost, the 30% has to be calculated on that. They have not done that. And that too on the previous 2023 tender, that was only 1 crore something. Assuming on their own document, basing on their own calculation, it comes to 3 crore something, and 30% of that comes to 1.14. So that should have been the criteria. Why sudden spike to 500%? There's no logic, and they have not indicated the estimated cost in the tender itself also. That's non-disclosure. That
I'm appearing today for the Jagannath Temple after notice. I need to take instructions. Under 2 things I will submit my notes.
Whether this particular notification which they are relying,
Yes.
issued by the central government,
Yes.
that 30% of the estimated cost should be the annual average turnover,
Madam,
has any application to you?
that I have to text.
That is the only thing.
Yes, ma'am. Your lordship may.
If it has an application, then we'll have to follow the mandate. If it does not, then
They have also several other objections. Your lordship may kindly come to phase 25. Phase 20.
he's not pressing those objections. He's pressing this point,
Right.
considered to be the
Right.
most lethal weapon against you.
Yes, ma'am. I'll take instruction. Your lordship may, in the meantime, the tender process has been complete and we have given the letter for the reverse tender to execute the work in the meantime.
So easy. Debarring the other persons.
We have not given, and we have only given them letter. And to be fair to the court, I have given them letter to accept, not so. I need 1 week time.
You have not issued a work order.
No. We have given them the letter to accept.
Yes, come on next Monday.
Yes, ma'am. Next month. Yes, next month. Next.
Record his submissions. He appears and is for an explanation. Take instruction. Yes.
Item 25.
25, Your Lordship, on behalf of Mr. S.S. Kanungo, I pray this matter may be taken up next week. He's out of station. That's next week. Some urgency.
After vacation.
Thank
We
you.
are giving you a larger time. You are asking for a smaller time. We are giving you more.
After 15. There's some urgency in this matter, but he's out of station. My Lord.
Appearing for OP number 2, we have filed a caveat in this matter. They have not served as a copy.
Copy. Date recorder appearance. Copy to be served. Copy to be served. Next.
Item 26.
Item 26, Your Lordships. The impugn order is at page 13, Your Lordships. May I just place it from...
There is no appeal against the judgment. For second appeal is concerned, I have not received the copy of the W 268 of 46.
You are for?
I am for the respondent number 10.
10. In both.
Hello?
In both the matters.
Perhaps in second matter also. You can make a.
In my case, an assume interim order is required for which it was mentioned. And in this matter, our pleadings are also complete. I just take your lordship, may not take your lordship much time. Kindly come to page 151. This is where the proceedings started in the court of the Land Reforms Commissioner, Board of Revenue, Cuttack. An application under section 15B was filed by the opposite party number 10.
What is this 15B?
15B is revising an order to correct the record of rights.
It is for correction of the record of
rights. An application. Now you are not
15 of what act?
Orissa Survey and Settlement Act. OSS Act. Now kindly come to page 156. 156 is the concluding part of this order where the Commissioner directed. The Tehsildar Kujang is therefore directed to correct the ROR within 3 months on receipt of the order only after proper field inquiry and verification of the related documents following due process of law.
Then what he has decided? Nothing?
He has remitted back the matter. This order was challenged by Paradip Port Trust in the writ petition, out of which the appeal arises. Now, when the writ petition remained pending, this order was worked out, and my lords, this order was worked out, and the Tehsildar has passed a final order. That final order, my lords, I have filed by way of an additional affidavit. Your Lordship may kindly see Annexure 5 there too.
What he says? Correct the entry.
He has rejected the mutation application. He has found that he has absolutely no cause of action to file the application for correction of record of rights.
Then what then what the writ petition does?
Writ petition. This was never brought to the notice of the writ court, either by the opposite party number 10 or by the state or by the Paradip Port Trust.
Yeah.
Exercising futility.
What the writ court did?
The writ court has confirmed the order of the Commissioner.
So order of the Commissioner was not it was indecisive.
Yes, sir.
Or it can be said to be undecisive.
Yes, sir.
You have simply relegated the entire thing to the Tehsildar to do that.
Tehsildar has adjudicated, passed a final order. After that, assailing this order, nothing has been done. But what the opposite party number 10 now intends to do is to forcibly enter the land on the basis of the order saying that I have succeeded.
It is neither here nor there. It is neither here nor there. It is you who have to protect your own property. So that cannot be. Only thing is the order of the collector is affirmed. That's all. Which does not really postulate any kind of adjudication.
Correct.
May I submit the earlier, my lord, the Paradip Port Trust has filed a application that is 3038 of 2003.
Confirm means who challenged that order? You.
No,
who challenged the order of the collector?
I was never party. Your Lordship has
How can you challenge the order? It was not a final order. It was not a final order, sir.
We challenged it.
How? And what? It is not no adjudication was made. No prejudice could have been caused. Cannot be said to be an aggrieved person.
Correct.
So
before the single judge, during the pendency, the order was worked out. So that
but that was not brought to the notice of the court
at the time of final hearing.
Correct. So simply affirmation of an order. I do not know who is the appellant.
No, but now there are two appellants.
Now you are.
I am a lessee in respect of the land, my lord.
So why you are challenging the order of the single page? What it has caused prejudice? Nothing.
Single judge has gone one step ahead. Kindly see the order of the single judge.
Saying that the private party is entitled to that record. So it goes one step ahead from the order which was.
And the Tehsildar still says that the private opposite party is not entitled.
Yes. Tehsildar still says, but the Honorable Single Judge went one step ahead.
Tehsildar said subsequent thereto or
subsequent to the order of the remand and not subsequent to the order of the High Court. During the pendency of the writ.
So have you brought that by way of an additional evidence?
Where, my lords?
Yes.
I brought it. I brought it on record.
In this appeal.
How?
By way of an affidavit.
Additional
affidavit filed on 4th of
additional evidence.
additional evidence.
Order 41 Rule 27 I'm talking about.
Yes, my lord.
Where is that application?
Application as such.
It has to be.
I can make this application out.
It has to be, because these are the documents which was not there, nobody produced, which would have tilted the entire decision. So in effect, without challenging this order of the Tehsildar, this order remained contrary thereto. This cannot be done.
Correct.
Second appeal is filed by who?
By the court as well.
Well, everything. But why? Oh, you wanted that property is yours.
Property is ours and we have leased it out to the appellant of Mr.
They
Mukherjee.
submitted my lord one line. Earlier Paradip Port Trust has filed the writ application in the year 2003. Where my lord the state has filed the counter that the documents have been prepared by practicing fraud by the Paradip Port Trust and the settlement authorities. And there is no named accusation at all. Not a single beneficiary has got the accusation. There is no 4-1, no 6-1. Sir, just a minute. There is no 4-1 notification. There is no 6-1 notification. Neither our plot has been included in the notifications, and they have
Who is in possession?
Pardon? We are in position. While the writ application was there, they have violated the order. We filed an application for violation.
He has been.
We are in possession.
Pursuant to my FIR.
Entire villagers are in possession.
Oh, villagers are in possession.
My lord, not only
What title the villagers have?
my lord, the entire village has been
I am asking what title the villagers have.
all are the recorded tenants, my lord.
Recorded tenants?
31 settlement.
What?
In 1930-31 settlement, all the villagers are the recorded tenants.
Okay.
Not only I, the single person.
That was the, what was 31 is what act?
Thereafter, no settlement has been done.
What act? What act?
Pardon?
31 is
Odisha
the
Tenancy Act, my lord. Odisha Tenancy Act under section 113 of the Tenancy Act.
Tenancy Act applies to, you are tenant under whom?
Under the ex-intermediaries. Under the ex-intermediaries prior to 1913, but it is on ex-intermediaries.
Ex-intermediaries, I do not know. I understand, I think prior to the bifurcation, it is a Bengal Tenancy Act which was applicable. It prevails. In a Bengal Tenancy Act, where is a question, where is a concept of ex-intermediaries? Are you a Corfa tenant? Are you what? Under the Bengal Tenancy Act, tell us.
Well, so far 2030-31 settlement is concerned, you know, we are the recorded tenants.
No, recorded, I understand. You know the entry in the record of right neither creates a title nor extinguishes a title. It is a two-settled proposition.
Yes.
But it has a presumptive value of its correctness.
Yeah.
It has a presumptive value of its correctness. So now I just wanted to know that what inchoate or vested right by virtue of that particular settlement, what vested right is created in you as a tenant? Tenant must be under somebody.
Yes.
If you talk about the intermediaries, then I do not know, after the Jamindari Abolition Act that came, it must be a corresponding act here also.
Here also.
Intermediaries right vested.
After 1 August 1946.
48. 48 or 46, yeah.
46, ma'am. Yeah,
46. 48 in West Bengal. State Acquisition Act that came. West Bengal State Acquisition Act that came. Which says that intermediaries right vest, royalty right
remains. We are the royalties, my lord, under the ex-intermediaries in the year 1930-31.
But if the question is that who was intermediary and how the right of the intermediary vested. If it is vested into the state, then one has to understand that how the vesting has come. I have to just look into the law. You just show me when you are taking a plea. Show us.
So for 1984 settlement, ROR has been filed here. That is a fake one that has been finding of the Land Divisional Authorities.
What fake?
Because there was no settlement since 1930 till date below. There was no settlement at Paradip Board.
But the property remained with the government.
But the ROR has been prepared by practicing court, that is the affidavit filed by the state government. State government has filed an affidavit, counter affidavit, showing that the document has been prepared by Paradip Port Trust in connivance with the settlement authorities. And
Did they challenge it?
That it was disposed of.
That it was disposed of where we are not party at all.
What says? The writ says what?
That was a dispute between the state of Orissa and Paradip Port.
True.
That was due to the interference of this court. That was amicably resolved between the state and Paradip Port, and all those 6,000 odd acres have been resolved by the chief secretary and the chairman of PPT, and that forms the basis of subsequent development in Paradip Port. So now, if he's questioning an affidavit in 2003 writ, where was he? So,
but that has gone. That was no.
Affidavit made by Tehsil.
And he did not challenge that order of the writ.
No,
he
hasn't.
He did not.
So this question of fraud and all, from where my friend is getting,
that is the
that has been disposed of. It was not found to be a fraudulent one. Mere alleging a fraud does not mean the document becomes fraudulent document. If the court does not adjudicate upon it, they may have taken it, and ultimately it was disposed of without declaring that it is a exercise.
Let the Paradip Port satisfy that. No land has been acquired, and I have been compensated.
If the state is the owner,
yes.
Now the question would be that how the settlement is done. That's why I wanted those acts.
No settlement. Your lawsuit direct the state government to produce the document.
Nothing you go and challenge your right in a civil suit.
And one suit has been filed by the Paradip Port Trust, which has been dismissed against the secondable file that has been withdrawn.
What suit?
I don't know. As far as I am concerned, he had filed a suit.
I have filed a suit which is second appeal is pending.
Where my
second appeal at whose behest? Second appeal at whose behest?
My behest against Triveni. Because
pending.
Yes, only for Triveni.
Admission done.
No.
That I have to take it.
No.
I have no.
Claim has been rejected.
So order 7 rule 10. 11.
Order 7 rule 11.
D or A.
Both.
Clause D or A.
Both. A and D both.
Non-disclosure of cause of action and barred by law.
Yes, Father. And barred by law. When it was rejected, against that he preferred an appeal. Appeal was dismissed. Now he says that he has filed an appeal, second appeal, which I have never heard of. And this was 3 years back.
But it has not been admitted, sir.
That I have to take it. So I have no knowledge about that admission. But the fact may not state whether my land is not. That is the only question.
Nothing, no question. It cannot be.
When land has not been acquired, then I will know that
you must be an owner of the property under Article 300 capital A, which cannot be done in this way without the acquisition proceeding. Here your right is not very clear. You are talking about a settlement sometimes in 1930. I just say intermediary, who was an intermediary, you are unable. Ex-intermediary. Now once the right of the ex-intermediary extinguishes, then royalty right, if it is preserved under the act, what is the subsequent act which has come? Because I have come from a state where there is a very different laws that has come.
No. And the Land Revisional Authority has held that a document which is also not filed here, a document where there is no plot number available. And my counter before
this is you take out, sir. Unnecessarily, he is taking me to another domain. I do not want to go into that domain. You just bring that decision by way of additional evidence.
I'll do that.
You do it. Let us see. And then we'll say this appeal itself is a premature one because it was not a decision which can be said to be binding. And that is corroborated by this evidence that the Tehsildar has taken an independent, and if anybody is aggrieved, it is open to him to take a step.
My friend has challenged the Tehsildar's order in a writ, subject to correction.
No, I have not challenged.
Not challenge, not challenge.
For the first time, we can do
And what he has done, I have also brought it on record by way of an affidavit. After the Tahsildar has dismissed his application, he has suppressed the dismissal, come in a writ petition in the High Court, and made a prayer that there be a direction to dispose of the mutation case expeditiously. And an innocuous order has been passed by this court, this honorable court, where it has been suppressed that the mutation application has already been rejected.
So that's why whenever I used to pass, I say, if not already disposed of. I always used to write this word. To dispose of within 6 months, if not already disposed of.
So I'll file that order 41. In the meantime, your lordship may restrain him from.
Restrain him for what?
Restrain him, he is forcibly on the strength of the order of the honorable court, on the single judge's order, he is forcibly entering the property.
My lord, I have brought this additional affidavit. Can you see that there is a provision order? Last by the sub-collector. Exercise the power under section 163.
But that was subsequent, year 2, 163 order is again limited, my lord, do not, this is a fit case where he has to be restrained. Your lordship may kindly see IN number
163 means equivalent to 144.
Yes, lordship.
What right he has or what powers he has to pass a injunction?
He doesn't have that right. That is why I am before your lordship, my lord. Your lordship may kindly see after the single judge's order in the writ petition, what he has done. Your lordship may kindly take IN number 1469 of 26. Forcibly entered the land, has put up a hutment there, started living there. I had to lodge an FIR. The police had to come, remove all that, arrest him. Again, he wants to re-enter. And he's coming with a band of goons, forcibly trying to enter upon the property.
Make it a fencing.
But that we have done, but it's a 100 and some acres of land, 175 acres of land. Fencing, it takes time, man.
Take out an application within a day or two, please come. We can dispose of the matter.
Make the application tomorrow itself. I'll
please make it and come. Unnecessarily on hovering around the interim order.
Your lordship may call this matter day after tomorrow.
No, you take out an application. Let us see. We will take note of the subsequent or this event and then dispose of the main procedure.
Yes, your lordship may call it here.
Day after tomorrow. And ensure with your junior
service
copies are served in advance. Otherwise, nobody would come and say, I have not received.
That I will.
Appeal memo may kindly be solved because there are 268 of
The other case, appeal memo.
Yeah.
The recorded here sound.
47.
Copy has been served.
Already.
The lordship, here for the petitioner and the senior will appear.
Item 27, Your Lordships. Your Lordship, the impugned order is at page 13. May I place it from paragraph E onwards?
No, it's not required. That's passed in your favor and you are challenging the order.
Lordships, the case that we wanted to make out before the single bench was this, that if at this point we are directed to file the show cause, then obviously, Your Lordships, I would be...
Only thing is that they will proceed to record whatever the evidence, whatever is there, but they say no final order shall be passed. That means the final adjudication would not come.
Your Lordships understands how a criminal case is conducted, Your Lordships.
No, this is not. Sorry.
May I have a Supreme Court judgment in my
Yes. M. Paul Anthony, you start from there, then GB Tang or whatever. Judgment? No, there has been a departure there from.
Your Lordships, I am aware. Your Lordships, may I just say?
No.
Your Lordships, I think there is not a complete bar that when there is a criminal case of
That's why I say it started. The first judgment is the M. Paul Anthony.
But Your Lordships, the Supreme Court also stated this, that in grave issues, if the defense and the entire case, all the basis.
I do not know. Convince my brother. I am stuck with my own judgment.
Your Lordships, I'm citing Supreme Court judgment. If Your Lordships,
Yes, I am stuck with my own judgment. This on the basis of all the Supreme Court judgment.
Your Lordships would just allow me to convince Your Lordships. May just look at the judgment.
The Supreme Court judgment. Which one?
Yes, Lordships. My associate.
What is this? GM Tang or what?
No, Your Lordships. This makes the position very clear. Para 9, Your Lordships. There is yet another point which remains to be considered. The Industrial Tribunal appears to have taken the view that since the criminal proceeding has started against Raghavan, the domestic inquiry should have been stayed pending finalization of the criminal case. As this court has held in so and so matter, it is desirable that if the incident giving rise to the charge framed against a workman in a domestic inquiry is being tried in a criminal court, the employer should stay the domestic inquiry pending the final disposal of the criminal case. It would be particularly appropriate to adopt such a course where the charge against the workman is of grave character, because in such a case, it would be unfair to compel the workman to disclose the defense which he take before the
subsequent judgment of Justice UC Banerjee, Omission Banerjee of the Supreme Court is also there.
Your Lordships, I think both the propositions.
A principle that a person cannot be compelled to give an evidence against himself.
Your Lordships, may I just, Your Lordships, in this peculiar case, Your Lordships, see, even the witnesses which are going to be produced before the disciplinary actions are the vigilance officers, Your Lordships. That's the issue, Your Lordships.
Understood, because what these line of judgments initially were that if the disciplinary proceeding, you have to lead an evidence, but in a criminal proceeding, you can simply say, I pleaded no guilt, I plead innocence. So now it is the prosecution who has to lead. So giving them to give or compelling them to give an evidence will be used against them. So this is what the principles was, but that has been subsequently diluted.
Your Lordships will kindly also appreciate this one more angle to this.
No.
Your Lordships, when the vigilance case was, the FIR was filed.
There's an article, there's a constitutional provision.
Your Lordships, within 2 days, they compulsory
provision.
There's another issue to this matter, Your Lordships. Your Lordships, the day they issued the vigilance FIR was registered, within 2-3 days, they compulsorily retired me, Your Lordships.
So?
And the matter then thereafter, Your Lordships, that compulsory retirement was set aside in 2025. Thereafter, they issued this disciplinary action. But meanwhile, I have already retired also. My age of superannuation has come. So they basically issued this to me at the age of 63.
Yeah, whatever be. No. Yes. Let it, I think even if the single bench has really gone beyond,
We are not saying about quashing, Your Lordship. We are just saying that let this halt till the criminal action. And Your Lordships may also say that let the criminal action be completed also within a time frame. We are okay with that also, Your Lordships.
No. Why should we? as an appellate court emanating from a writ jurisdiction of a civil nature, directing the criminal proceeding to be disposed of.
Your Lordships will also appreciate that, Your Lordships, this charge sheet also has not been filed in this matter. And if this stage I disclose my defense, it's really going to harm my criminal case, Your Lordships. Charge sheet has not been filed. Vigilance case was initiated somewhere in 2021, Your Lordships. They could have easily issued the charge sheet. They kept it pending. This was only issued to me because somehow I got the.
This is UC Banerjee is judgment for the charges against you.
Lordships, state would be.
Is that page 35 is article of charges. These are two different altogether.
Why you cannot say what are the charges against you?
Charges is that they are not.
You say state can say when annex the document, madam.
I thought Your Lordship asked who's against me. I could not hear Your Lordship. Your Lordship,
This is a documentary evidence which is there. You are fighting.
Yes,
Will you not say that what are the charges against you?
Your Lordship, I could not hear Your Lordship. That's what I'm trying to say. Your Lordship will find that at page 36, Your Lordships. Same assets. May I just place that page 36?
No, articles of charges, let us see.
35 years.
It's completely on the basis of that vigilance.
That's a statement of imputation. That's another thing. I'll go. I was just looking at the article of charges. Oh. What is his designation? Sub-inspector.
Sub-inspector.
BMW.
SP.
Huh? Purchase BMW, sub-inspector of police.
Well, yeah, so that would be the merit of the matter, Your Lordships. I really do not know the merit of the matter. I'm only on this very short point.
Nobody can buy a domestic scooter. Your client has bought a Swiss scooter.
Lordships.
Very interesting.
I think they had some.
Even was very good for his son. He has given a racing the motorcycle. The rocket 3R bike.
His wife probably has a business because I think she has a ultrasound clinic or something. They run that also. It wasn't only in his name.
Yes.
Only two things are violated. That is, he has dereliction in duty and failure to mention absolute integrity. These are required. The provision speaks 21(1) that he has to submit a property statement every year. What was the property at the initial state of joining, and thereafter he has to submit every year. He has not submitted that, and subsequently it was also said that every 3 years he has to submit. That also he has not done. Therefore, the proceeding has been initiated for violation of the Rule 21(1) and Rule 21(4). And
so what he has not received any retirement benefit.
He has received. He has received.
Oh, retirement benefit he received.
Yes.
He was compulsory.
At the time, initially he was prematurely retired, compulsory retirement was given. That order was challenged before this Honorable Court. This Honorable Court said that premature retirement is given that he will get all benefits and other things. Why don't you initiate a disciplinary proceeding against him? Only on the observation made by this Honorable Court, this disciplinary proceeding has been initiated. That order is, I'm placing that order. That order is there.
We are not concerned with that.
That order. Page 31.
And what is the vigilance cases against?
Vigilance cases, these are disproportionate income. That is totally different from this. Here is the case of misconduct. Why he has not submitted the property list? How much he has acquired during every year? He has to submit. And not only in his name, his family member's name, how much property he has purchased.
Yes.
That he has to submit. That he has not submitted. Only because of that.
I got it. Your contention is that it has got no relation to how you have acquired the property. It is in relation to why you did not disclose that you have acquired those properties.
Exactly. So that is this.
And he's disowning that these properties are not acquired by him.
No, he has not disowned till then because it is in his name, his family member's name, his son, his wife, and his name. All properties are there. You have given the list of properties.
No, I understood.
Yes. So that is with regard to disproportionate income. That has got nothing to do with these present things.
Yes.
You know, so the witness which have been called are the vigilance officers only.
Oh,
in the disciplinary action. Whom otherwise would have been crossed by my lawyers in the court, in the vigilance court.
No, the court had said that. No. Find out a judgment like this. This 64 judgment has been subsequently dealt with in at least 2 or 3 judgment. I can lay hand to it.
His entire case that he is saying that both are the same and identical. It is not a normal criminal case like other criminal cases. It is a vigilance case. It's not a criminal case. The vigilance case where he has to show that disproportionate income. Our case he has not submitted the property list.
So what will happen ultimately if it is found that it is a disproportionate to his income?
Then punishment will be there.
What punishment?
The criminal court will give the punishment. Vigilance court will give the punishment. Either recovery or something else that will there.
So it is. You say it is not a criminal proceeding, as you say.
No, it is criminal proceeding, but different type. It's not that it's
not different type. I just wanted what can be a different type of criminal cases.
Here in this case, punishment.
It's a criminal offense if you have done it. What is this? Only thing is, in this state, there is a special court which is designated as a vigilance court, where you are simply trying or deciding a case relating to these.
Yes.
That's all. That's a specialized court. But it is the same proceedings, sir.
No.
Same application. The procedural law, everything is same. Is it not? Are they not guided by the BNSS?
They are guided.
So,
here is the place we only see that whether he has furnished the property list or not.
That is GM Tang. GM Tang is there. HON'BLE is the first judgment. No, it is that giving an evidence against himself.
You can see section 21 of the Odisha Government Social Conduct Rules. That rule says he has to submit the property list and the list of properties acquired by his family members. He has not submitted. Therefore, we have only initiated.
Yes, that's your case anyhow. Yes, that is Article 23. Article 20, sub-article 3. You will find out judgment on this article 20, sub-article 3, clause 3. Yes, you will consider. We don't think so. We are keeping this matter day after tomorrow. We will make a research on the judgment. She is relying on 64. There are judgments on Article 20's clause 3.
Your Lordship, it can come on 14th, Your Lordship. 13th, I'm out of station. The 14th, it can come. Your Lordship are keeping it day
But
after.
on 14th, we will be out of mind.
Your Lordship and Lordship will not be out of mind.
Yes.
14th, Your Lordship.
14th.
13th.
Mark. Item number 28.
Was the appellant who was a diploma degree holder and was initially appointed as technical support engineer under the respondent. I was challenging the order of the honorable single judge, Annex 4 matter, whereby the discontinuance notice was under challenge, and though the honorable single judge initially granted protection in interim order 2023, but in the final order matter, you have to kindly have Annex 4 at 11 page 238. Without interfering the discontinuance notice, the honorable single judge directed that kindly see at page 238, the operative portion at para 6. Having had on come to the parties and the commission made this court while disposing all the three petitions without interfering with the interim communication dated 28/6/2023, observe that in place of the petitioner, no such fresh engagement will be made by the opinion number 5. It is further observed that as and when there will be any requirement with regard to the nature of work discharged by the petitioner, the petitioners will be given preference. It is further observed that
Serve opposite party respondent number 5.
Hi.
Notice to respondent number 5.
Only a
My own judgment is staring at my face.
Notice on I.
Manabasa Devi is a judgment which is staring.
Notice on I.
29.
Yeah.
Even the next norms in the page 30.
A judicial order is challenged.
Yes, the problem is that you are
We are already in a process of deciding the same. I think this week it will. No, other judgment has been done. Sun flag or something has been done. There is another matter which we have just kept it for orders.
NKC is there.
I know there is a recent judgment which we have kept it. Just keep it. You just find out if that judgment will deliver.
Check my NKC judgment. What is it about?
No 226 lies to judicial order passed by the civil court.
Why could not give it to the order?
By civil court.
This judgment is dated 10th March. And
We have to consider Suryadev Rai has been diluted in Radhesham, and all these judgments we'll have to consider. We have considered, we are in the process of considering the same.
This was never raised before the single judge. I understand, because it was not.
It is not a pecuniary or jurisdiction. You can waive your right under section 21 of the ECPC. It's a inherent jurisdiction, plenary jurisdiction. Then in that event, it cannot be waived. If the court lacks jurisdiction from Kiran Singh's judgment, no jurisdiction.
Relied upon Radhesham and
54 Supreme Court, so that has been said. No, day after tomorrow, and there is one. We discuss that matter. That's
Item 30.
day after tomorrow.
Yes.
Takeoffs, that is died is WA number 13,761. That is second item. Item. People matter, we are not with facts of the case.
There is a defect.
Defect that delay for that I have filed an interlocutory application. That has
the copy.
that has not been tagged.
Notice in
I number one.
that has to be because you are challenging the same order. But
Man.
then service let them service here. Fine. 1 week. Notice. Yes, please.
Item 31.
Why you are not filing 3 and 4?
Everything I have filed.
Where
I have given the copy. And there is the receipt also.
you have not filed.
Yes, we will. I have filed.
For 3 and 4.
There was his name also has been reflected in the list viewer.
Here is where their presence is necessary. Last time we directed.
I had also reminded him. I had also reminded him to that as per the directions report of this.
They are answerable.
I do not 32.
Please, sir. Because in this case, on the last occasion, Mallots are directed for a written note to be filed by both sides. Malot, our written note, Malot, I'll file before the next date. But Malots may kindly see a written note has been filed by the appellant. That is the flag B, Malots. Here, Malot, they have filed certain new documents with the written note. I'll explain. Which, Malot, they have. Just a minute. I'll explain. Lordship takes that flag. Yeah, I'm obliged. Lordship takes that flag. Those were not part of the decision, neither the writ appeal, and they have been, Malot.
Let us see what is this here. Flag.
Flag B, Milord, is the written note of submissions filed. The Lordship would get page 4, Milord. Page 4 and 5 is part
Copy of the appointment order.
Milord, that's part of the service book which is already on the Lordship's record.
Which page?
23 onwards is the service book.
No, copy of the appointment order.
Milord, page 23 onwards is the service book, Milord. I have photocopied that, enlarged it and filed it.
Which one page?
Page 23 onwards. Page 23, Milord, is page 4 of the written note is an handwritten. Milord, this is a handwritten copy. The same thing is there at 23 onwards, which is the typed copy. This is the difference. And if your Lordship skips the
This page 24 onwards is this is E mode file.
That's right. That is the HRMS copy. Same service book, Milord. Lordship may rely on what is on your Lordship's record. And Milord, what my learned friend refers to at page 7 of the written note, Milord, is her latest pay slip, which demonstrates she's a regular continuing employee. That's all. And the last one. And the last
vital one. Then why you did not give them an opportunity to pay? You can't rely these documents.
Lordship may ignore it. Lordship may ignore these 3 documents. Please ignore these 3 documents. And the last document is the service conditions, which is also part of the writ appeal record. I will only take 2 minutes to place before your Lordship the relevant provisions, my eligibility and how the learned single judge is earned. I will just require 2 to 3 minutes. My Lord said permitted me to file a written note, my Lord. I did not file because 3 weeks ago written note was directed. Yes, my Lord. I have filed. Since some new documents they have, my Lord.
No, these are nothing. We can't accept in the written notes.
So my Lord may give me.
But it does not mean that you will just wait for.
My Lord may give me one
you ought to have done it. Point out that these are new documents I have not dealt with.
My Lord, I have received the draft written note, my Lord. My Lord may give me 1 week time before the next week, my Lord, I will file. This is the first extension.
This is something you wanted to delay.
My Lord may give me 1 week time, only 1 week time. I have received, my Lord, the draft written note. I will file it before next week. Lordship's kind consideration is whether I would be eligible. The 7 years of service would be taken from the date of completion of my constable training, or would it be taken as 7 years from the date of regularization? The rule says from the date of completion of constable training. If I may just place the rule for your Lordship's kind consideration. That's at 264. And the learned
the single bench has gone in.
The learned single judge has heard with utmost respect saying that it is 7 years from regularization.
From where he got it?
That was the argument advanced by the state in their reply.
Have you invited his attention?
I have. Lordship gets 264 for a moment. That's the eligibility. And this is not promotion from constable to ASI, for which I have to undergo the rigors, page 264 for a moment. If your Lordship gets Regulation 3, eligibility for appointment of Assistant Sub-Inspector of Police. The Constable, Landsmack, Havildar, Crime Intelligence Havildar in each police district, and those on deputation to other police establishment from district police cadre who have completed the constable course of training and have completed 7 years of service from the date of completion of the constable course training, as on the first day of January of the year, and sepoys constable or battalion, etc., etc., etc. That doesn't concern me. I am a constable.
One says that we are eligible to appear in the written examination.
Hello, I have appeared in the written examination. My written examination result is kept in a sealed cover. All I am seeking is please permit me to go for the training. Let them take their time. Please permit me to join the training, because there is the last batch which is going on. And if I don't make it in this batch with your Lordship's kind benevolence, I lose my opportunity of being even considered, because I'll be age barred, etc.
Training for
ASI appointment. So in case the state seeks time and your Lordship is inclined to grant them some time, please permit me to join the training, subject to outcome of the interview.
When the training
is ongoing, in batches, and this is the last batch which is going this month. And if I don't make it this month, I lose my...
Lord, why it has been kept in a sealed cover is in persons to an order passed, an interim order passed by this Honorable Court in a previous writ petition.
Which is disposed of.
That has been disposed of, my Lord, and when it was disposed of, the status of the petitioner, his regular employee status was taken away. That is the reason why my Lords will come to the interim order.
taken away?
Yes, my Lords. My Lords may see. My Lords,
order.
No, my Lords. My Lords, the orders by which they were regularized, those were quashed, and a direction was issued, my Lord, for a fresh exercise to be conducted for not only regulation of the petitioner, but a number of almost 1,000 other persons. Now, my Lords will see why in the impugn order, that is at page 270. Page 270, my Lords, of the appeal, my Lords, that is the impugn order passed by the Honorable Single Judge, page 270. And the relevant portion that I want my Lord's attention to draw to, my Lord, paragraph 7 at page 272. Why the Honorable Single Judge refused, my Lord, to allow them to go for the training is at paragraph 7 and 7.1. They were regularized by order dated 10/11/2020. Prior to that, they were working on ad hoc basis, but the same has been interfered with by this court by judgment dated 4/11/2024, in the very same writ petition where, my Lord, interim direction had been issued for the results to be kept in seal cover. This court, while quashing order dated 10/11/20, which is the regulation order, has directed the opposite parties to consider their claim for regularization in terms of order dated so and so, which has not yet been implemented. Since petitioners are not regular employees in the eye of law,
Still, it has not been regularized.
no, my Lord, that is, my Lord, my Lord, it has not been done, but my Lords will kindly permit me to take instructions. That is why, my Lord, I was also praying for 1 week's time.
And my Lord, this judgment, which has attained a finality, is at 262, is dated 4th of November 2024. So, assuming the worst against me and assuming regularization is a sine qua non, can I lose my right because the state sleeps over the matter from 4/11/2024?
This has happened in persons to a judicial order passed by this Honorable Court. How we slept over the matter, my Lord? I fail to understand.
And your Lordship will also see that counter before the single judge at page 200, where they say that I am in the list to go. Page 200 for a moment also, my Lord.
And that order, my Lord, where their regular status was overturned, that has attained finality. I don't think any appeal has been filed against that judgment passed by this Honorable Court. So this order, which is impugned, this is a consequence of the order passed in the other writ petition, my Lords.
You have a copy of that order?
Yes, my Lord. It's
annexed, my Lord. It's annexed to Lordship's record. I've annexed the order.
Earlier.
Yes, I've annexed the order.
Which was the regularization order.
Page 217. Place the relevant portion, my lord. Relevant starts at 260.
The bottom line is that regularization order goes. Yes, ma'am.
Lord, if I may place, Lord, if your lordship takes 260, Lord, the regularization was the impugned order which was under challenge was an order of regularization of employees who were already regular. Hence, the Honorable High Court, my lord, the learned single judge, threw out that order. Lordship gets that at 260. Lordship gets that I am a regular employee from 2008, working continuous. I was made ad hoc because there was an error in the reservation made by the state government. And the error was that the SCBC quota had been taken to 27.5. That was frowned upon by this Honorable Court. Hence, they recast the list and made me ad hoc. I came to the Honorable High Court saying, once you have conferred a status on me, you cannot take it away from me without making me a party. The Honorable High Court will not consider the matter in a writ application, which was carried by the state up to the Supreme Court, and the orders of this Honorable Court were confirmed. And this Honorable Court directed that regularize these employees by making them a separate cadre and then encadre them according to your vacancy. Now, your lordship sees how the learned single judge in the first round dealt with the matter, page 260. And that will clarify the issue. May I just place that last 5 lines? Accordingly, the opposite party number 3 is directed to review each and every of the 773 employees who were found beyond the 50% reserve category quota. While reviewing their cases, the OP number 3 and their respective district heads of police shall do well to ascertain the vacancy position post the 2006 advertisement. Since it's a matter of record, 261, that no further recruitment took place from the year 2006 to 2012, and a statement was made before this court, which has been specifically recorded in the order dated 14/8/2012, to the effect that there were 10,000 vacancies at the relevant point in time, and attempts shall be made to regularize the service of the petitioners against such vacancies. Such regularization shall be made strictly by giving due regard to the seniority of the petitioners, as per their position in the merit list of the recruitment test of the year 2006. It is further made clear that the present petitioner shall be kept above in the seniority list to the persons who have been appointed pursuant to a selection process carried out post the year 2012. Since the petitioners are getting the regular scale of pay with all service and financial benefits, no further direction is required in the aforesaid regard. However, it is made clear that no recovery shall be made from the petitioners consequent upon their regularization in service. Furthermore, it is also directed that on the basis of the refixed date of regularization, the experience of the petitioner shall be counted from such date, and subject to their fulfilling the eligibility requirement, they shall be allowed to participate in the selection process for the promotion of the next higher rank. Next page, 262. Keeping in view the peculiar facts and circumstances of the case, as well as the direction of the Honorable Divisional Bench, as discussed here in above, writ applications are allowed, no order as to cost. Now, this order is passed on 4/11/2024. You have kept sleeping over the matter. Now, kindly see the counter they filed at 200 before the learned single judge. In the second round, the counter they read, Millard, I placed the counter, this is the state's counter in this second round. The Special Central Selection Board for the year 2025 selected 136 unreserved category candidates.
You file your
Yes, sir.
written notes
Yes, please.
by Thursday.
My lords.
We can't give you much time.
Not this Thursday, next Thursday.
This Thursday. Next Thursday.
Not 1 week time, maybe.
No.
And Millard, I am at serial number 1999 and ready to go.
No, beyond. Thursday you. So that he can go in a training.
I'll try my best, Millard, but
No, if you cannot, then we'll decide.
yes, Millard.
It's a question of all
Yes,
these procedures.
if I cannot, then the matter.
Pass.
Yes, that's right.
Which
If I cannot, then the matter may be decided, but I'll try my best. Yes, Millard.
Okay.
Millard, may I appear on the top of the list subject to like I'm deeply obliged.
On the top of our name also.
I'm deeply obliged. Lordship would appreciate this.
Where it is so that I get a fair chance.
Well,
So that's very competition.
Item 33.
My humble apologies, my lords. In the morning today, I was given to understand that I will not be appearing in the case with the CMC. They will appoint some other counsel. Unfortunately, because nobody has appeared despite my instructions, that is why this anomaly has occurred.
Are you grieved or not grieved?
No, I'm not grieved. I do not even have a wakalat number. I was given to understand that some other counsel will appear on the inform, which is the reason, my lords, I chose me.
Who is the some other counsel?
They didn't tell me. I was told that somebody else will appear and who do not appear in the case. That's when all these things. With short adjournment, my lords, I obtained the necessary.
Let us see. If nobody appears, we'll proceed expert.
Because next week or tomorrow.
Item 33.
This rate appeal was entertained and by order number 2 dated 30th of March, my lord was pleased to formulate the question involved there. The lordship may kindly recollect relating to that whether an IA can be filed after the writ has been disposed of. We had shown one judgment, recent judgment of the Honorable Supreme Court.
Oh, he was asking for a time on the other day.
That is for the IA was filed. Initially the Sarpanch was sacked, my lord. On the ground, initially a Sarpanch was removed, my lord. The order of removal was passed against him on the ground that he has not convened 3 consecutive meetings. Thereafter, my lord, that was against that order of my lord. He preferred a writ application, my lord, that was disposed by the single judge, my lord, directing to reinstate him, my lord. That was challenge in appeal before this one. That was challenged before this honorable court, my lord. The honorable court also confirmed this division bench, my lord, also confirmed that order. After confirmation of that order, my lord, they did not act upon the order passed by your lordship and also by the single judge, for which he filed a discus, my lord, for IA, my lord, in the disposal of case for my lord implementation of the order. And the direction was only given to implement the order, my lord. And my friend's submission is, my lord, that this case is maintainable, my lord. No IA is maintainable in a disposal of case, my lord. Your lordship may kindly see, my lord, only for implementation of the order and the order passed by the single judge and confirmed by your lordship has to be given effect, my lord. That has to be accepted, that has to be acted upon. But that has not been done, my lord. If I IA, my lord, that IA is not maintainable, your lordship may kindly see a decision of a recent decisions, my lord, in the case of last gay answering, my lord, that is by the Supreme Court. In this case, the case was disposed of on merit. IA was filed only for implementation of the order. The honorable court held, my lord, that implementation of the order is possible. A petition is very well maintainable, my lord, for implementation of the order because no substantial change they have made, no modification, nothing they have made, my lord. That is only for implementation of the order. Lordship may kindly see paragraph 18 of the judgment. Should I bless my paragraph 14, man. However, one of the 11 portions is after 5 to 6 lines, it is manifest that in the directions number 2, the honored single judge had clearly directed that the writ petitions would be entitled to be posted to a post in equivalent scale held by them when the letter dated 23rd April 2003 was issued. The respondent Indian Airlines was obliged to obey and implement the said directions. If they had any doubt or if the order was not clear, it was always open to them to approach the court for clarifications or of the said order. Without challenging the said directions, seeking clarifications, Indian Airlines could not recommend that the same on any ground whatsoever. If you got application of an order passed by the court, however, where it is the effect may be, its effect may be, is no answer for its own, for its non-implementation. In our opinion, in the miscellaneous applications, no press release, this is important matter. In our opinion, the miscellaneous applications, no press relief on the basis of a new cause of actions had been sought. It was an application filed for pursuing and getting implemented the relief granted in the petition, namely placement in the appropriate grant in which he was placed at the time when letter dated 23rd April 2003 was issued. This is precisely done by the Learned Single Judge by his order dated 4th March 2005. Without examining those factual aspects of the matter, in our judgment, the division bench was in error in holding that after the disposal of the writ petitions, miscellaneous application was not maintained. And the only remedy available to the appellant was to approach the authorities, and if this interpretation was not acceptable to them, then he could file a fresh writ. So my respectful submissions, my lord, this is fully covered by these decisions because it was only
Where is your IA?
Pardon?
Where is your IA, sir?
And
have you brought recent judgment of Justice from that? We have got for Justice
Diwala's judgment, my lord, we have given
us
an extra copy also. PDF page 117 of the lordship. We have given a hard copy. PDF page 117.
And that apart, my lord, my respect to submission, my lord, once a law, the single judge has passed the order and this division bench has confirmed, that has to be given effect, my lord.
Yes, here, but one my learned senior may allow. Paragraph 2, the lordship had specified
the IA, I just want. For IA inquiry.
They have not filed, man, I'll file it.
You have not annexed?
So we need to
I look at PDF page number 339. 39 of the writ petition.
The High Court, we have only, my lord, annexed this single judge order and also your lordship's confirmation order, since they are not accepting, since they are not doing that, my lord, since they are not acting upon your lordship's order, since they are not implementing that. And even my lord, considering my lord, even my lord,
my lord's order. March 2026, wherein my lord has specifically said about the tone and tenor of the order of the Honorable Single Judge, the original order. So there were two directions. One is you freshly consider revocation, and if that doesn't happen, then
71.
My lord had paragraph 2 of order dated 33, 2026, wherein my lord has analyzed both the orders and has said that the tone and I'm just placing that the tenet of the order prima facie indicates. My lord. Page 71, if your lordships would see, page 70, paragraph 6. So the first direction was to freshly consider revocation of snow. My lord, may kindly see page 70, paragraph 6.
Even accepting.
So first order is
no change in the second order. No change.
No, my lord, first order is to consider freshly reconsider revocation. So that the government doesn't do. The second part of the order is if you don't do it within that specified period, failing which immediate revocation shall take place. So now it is part implementation, and now the recent judgment says that the IA.
What was the original order?
Original order, my lord, was to reconsider the question of revocation of removal.
Correct.
So fresh decision the government had to take within a specified time. Now, in case that timeline is not adhered to,
yes,
then he will be reinstated.
Yes.
If the timeline is not adhered to, timeline is given.
Yes.
Then, so by impugned order, what he has done?
So the government didn't comply with the original direction of reconsidering.
I am asking the original direction. What was the original direction? It's reconsider the revocation of the cancellation.
Reconsider revocation removal.
Yes.
Reconsider removal. In case you don't reconsider within the specified
time, then automatic removal.
Automatic reinstate.
Then
in the impugned order, since the time was over,
yes,
the Honorable Single Judge directed for reinstatement.
Yes. Where is the order?
That is Annexure 1. My lord, page number 18. PDF page 41.
Yes.
And the writ appeal confirmation, which they are mentioning, my lord may see Annexure 9, page 17.
Was it confirmed
that was only confirmed only to that extent that we had no locus. It was the state to come for extension of time.
Whether it is made rightly or wrongly, that was confirmed by law, by division bench. That was not challenged in the Supreme Court. So that order is in force. The order passed by this division bench, my lord, by confirming the single judge is in force, my lord. That has to be given effect, my lord. Even forgetting, my lord, in this case, forgetting everything, my lord. But, my lord, this reinstatement, which was passed by the single judge, after being confirmed by the writ appeal by this honorable bench, my lord, and that has not been challenged in the Supreme Court, that order should be given effect, my lord. And given effect, he has said, the single judge has said, given effect, my lord, if this is illegal, whether my friend's argument is that should not be given effect because of this error, my lord. His removal is found illegal, my lord, confirmed by your lordship. And because of this, my lord, because he filed an IA, my lord, in which your lordship depicted the idea of filing an IA in which, but initially, my lord, this order, my lord, single judge being confirmed by your lordship has to be given effect under any circumstances. in an interim application is a directive to implement the order. How that order is available, my lord, also.
And relying on that, Ajay Jain, recently Delhi High Court has also decided. Ajay Jain, recently Delhi High Court has also specifically said that IA, my lord, has seen that judgment. There are specific directions that no such IA would be registered. In that IA, they have to say that it is impossible to get it executed, and then only that IA would be maintained. That paragraph, my lord, has. Now, another interesting thing would be, my lords, in the interim order, had specifically directed the state to comply my lord's division bench order.
Yes.
That has not been done yet. My lordship would see.
What has been done?
No, my lords may kindly see the division bench order dated 30th of March.
He's the appellate here, I'm trying to argue first. Yes.
My lord has specifically said that the tenor of the order prima facie indicates that revocation is not automatic. It is contingent order depending on the happening of an event or non-happening of event. The issue here is whether any independent application is disposed of in a disposal of matter is a proper course to be adopted. It appears that on the basis of an interlocutory application, further direction appears to have been passed, which raises an issue so and so. We therefore find a prima facie case made out. There shall be stay of operation of the impugned order for a period of 3 weeks hence. Para 5 not yet complied with. State is directed to disclose as to whether any fresh decision has been taken in terms of the direction passed by the court while disposing of the writ petition on the next day. So till now, state has not disclosed whether this fresh direction has been complied with or not. So the original direction was reconsidered. My friend appears. So reconsider revocation. Now,
yes,
this or not conducting 3 weeks.
Have you considered?
Yes, ma'am. I have got the instruction.
Why give a sitting mount?
Yes.
I find a very interesting,
Yes.
I would say, gestures. So you are first to respond before they open their mouth. Unnecessarily 20 minutes we have just heard the matter.
My lord, seniors are pressing the matter.
So what you say that now it has become we have passed the order.
Yes.
What's the name of your client?
Kavita Saf.
It's not difficult.
You can give me a copy of decision.
What you have done?
Direct to Panchayat Raj.
Very interesting, this one. Very interesting. We'll dictate it tomorrow, first matter. We'll dictate it and we know what to do. And
The recent Delhi High Court judgment also have given.
they have created a mess.
My only submission, my lord, on this round of technicalities, my lord.
You are a benefactor. You are a benefactor of state's negligence. Conscious or unconscious, I don't know.
But I must be the beneficiary of your lordship's order, my lord.
No. No. Absolutely no.
Because the order which is
because the government has to take a conscious decision on the merit. They have not taken a conscious decision on merit, which led your reinstatement to come. You are a beneficiary of their conscious or unconscious negligence.
That is not due to our mistake, my lord.
That's why I'm saying you are a beneficiary. You are the real, I would say, the achiever.
Beneficiary of your lordship's order, my achiever of your lordship.
No.
Yes.
Sir, the order was that you take a decision. That they challenge me, say that it is gone to the state. The state will take a decision ultimately. Why you are challenging? Go there before the state.
Yes.
Whatever you want. State is sitting tight, and that gives you a benefit. That smile has been brought into your face because of the state's inaction.
We have won the election.
That's what I'm saying. That smile has brought because of their inaction. Necessarily.
That item number 34.
Yes.
That engineering matter.